Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have. What's up, everybody? We are here today to talk about a very interesting case. It's Peter Tragos, the lawyer you know. And if you don't know, I am a car accident personal injury lawyer in the Tampa Bay area in Florida. And I mention that because the case we're talking about today is right up my alley and is very interesting. We make a living fighting for injured victims when insurance companies like GEICO try to do things to deny claim or not pay what a claim is worth for someone who has that insurance or is hit by someone who has car insurance. Now, it's a very interesting case because I find myself to be a little torn, which is why I love having you all as potential jurors to help me make a decision as to whether or not this case is fair. And I'm talking about a $5.2 million award given to a victim who contracted HPV in a car insured by GEICO from the insured on that policy, who is her ex-partner, from intercourse they had in that car. So it sounds crazy, but this victim filed a claim against the insured and against GEICO. It went before an arbiter, which is usually a very defense-friendly or insurance company-friendly process versus the jury system. But they go before this arbiter, and the arbiter awards $5.2 million based on the fact that over the course of some time, they had several encounters, several instances of intercourse in this motor vehicle that was insured by GEICO. And over the course of that relationship, she contracted HPV. Now, GEICO is making all sorts of arguments at this point, but the first one is so common and so frustrating and annoying when insurance companies do it that I do hope they lose on this count. When this claim was first filed and when a demand was made by this injured victim, GEICO basically buried their head in the sand, denied any liability, decided not to do anything, which is how it went before an arbiter and how this woman was awarded $5.2 million. Now, I haven't seen that arbitration award. I don't know if it's available, if it's private. A lot of the names have been redacted or shortened to just first letters of first and last name for the privacy rights of these victims, which we talked about before, and even the defendant in this case, the partner that may or may not have given the HPV, their name has been redacted out and is just their first and last initials. And the reason for that is privacy issues. We talked about why every case can't be televised. Well, this is why. People's business and medical information, they don't want it to go out there in the public, and the court should protect its citizens of its jurisdiction. And in this case, they decided to do that. So the first thing GEICO did was absolutely nothing. And apparently it's been reported that this victim sought $1 million as their first demand, which usually means they would have taken a lesser amount with some sort of pre-suit negotiations. Well, GEICO again decided to do nothing. And now their first argument is that their due process rights have been violated and they didn't have an opportunity to defend this case before the arbiter. And while I said I haven't seen the arbitration award, that usually means GEICO didn't even send lawyers, present evidence. They did nothing. They just let this injured victim go forward and make her case because they didn't care. They didn't think anything was going to come from it. But when they appealed up to the higher court actually sided with the victim in this case, which is pretty wild if you think about it. Because when you contemplate what car insurance is actually going to cover, bodily injury covers an insured, meaning, you for your car, you are the insured driving your car if you do something negligently that injures somebody. Usually what's contemplated in that is driving your car. If you hit another car, hit a pedestrian, hit a biker, then your insurance is going to cover that. Well, does it cover when you have intercourse inside your car and someone gets injured? This Missouri court at this point has said yes. So then the next argument GEICO makes, and by the way, That first argument that, oh, we didn't have a chance to defend ourselves, they do that all the time where they just ignore things. They want to deny it and they hope the plaintiff or the injured victim goes away. And a lot of times it doesn't happen. So that is not a defense. They're never going to win on that, in my opinion. And that is not one of the claims I'm torn on. But the other two, actually, the next one is the most interesting one, because they're arguing that they don't protect against intentional torts. And we've talked about this lots of times, how insurance policies usually, and in the Amber Heard case, we said the same thing. If her insurance is defending the case, they're definitely not going to pay the verdict because it's an intentional tort. And insurance policies and liability policies usually cover negligent acts, not intentional acts. Somebody can't intentionally go commit a crime or defame someone, and then your negligence, your insurance cover that. So in this case, they're saying this was an intentional act, consensual intercourse by all counts and purposes, and she was injured based on that. So we don't cover it. However, the argument against that is the intentional act of intercourse is not what caused the injury. It's the passing of the STD, which it seems like was an accident and was negligent. He didn't do it on purpose. He didn't pass it to her, this victim, on purpose. So if the passing of the STD was negligent and was done in the car, which is covered by GEICO, her argument is going to be that a negligent act by the insured with use of the vehicle caused her injury and her damages. So far, again, the arbiter and the first level of higher courts have all agreed with this injured victim, which is very interesting to me. Next, GEICO makes the argument that, I want to read it, that this case is barred by a number of legal doctrines, including fraud, collusion, illegality, laches, and unclean hands, which is basically a bunch of hogwash unless you have actual facts and evidence to back that up. And what leads me to believe GEICO has none of that is because it continues to go up through arbitrators and higher courts, and the victim continues to win. So if they had evidence of fraud or some kind of collusion between the parties, and what that means is, if you think back to the Murdaugh case, where he referred his housekeeper's family for her wrongful death case to his friends who are lawyers to sue his own policy, that's the definition of collusion. You and I can't get together to sue my big insurance policy so we all make money off of that. That's collusion. So I don't know if they have some evidence that the ex-partner is working with the victim to come together and sue GEICO. Maybe they're going to share the money because she's not suing him personally or not going after him personally for the money. She's going after GEICO, which that's a whole separate conversation of bad faith and how you go above policy limits on a case like this, where if there's only 100,000 policy, how are they getting $5.2 million? Well, there are protections in place for bad faith that you can actually assign your rights as the defendant. If you get sued for $5 million, say, whoa, GEICO could have settled this and didn't. So you also join and say, let's go get this money from GEICO, not me. And everybody can agree because that's the deep pockets. A lot of stuff like that happens in these cases. And if you all have questions about that, we can do it on another video. But for now, they're at least claiming some kind of collusion. Factually, I don't know what basis they have for it, but these usually are difficult claims to be successful on. So what do you think? Should GEICO be liable for this, knowing that an insurance policy is in place to protect against the negligence of your insured? Do you consider an auto policy, a car insurance policy, to protect from anything that happens with regards to the car? Because I'll say, in all fairness, auto insurance policies don't usually contemplate something like this. But if it happens in your house, or if some kind of SA, that kind of abuse happens in your house, I'm using acronyms for the YouTube algorithm, but if that happens in your house, your homeowner's insurance sometimes will cover that, not for the intentional act of the person that actually did it, but if there was negligent supervision. We have had that in houses that have had daycares in them. Things have happened to the children based on or from older children in the house. And so the owner of the house or the owner of the daycare has that policy because it was negligent supervision on their part. They weren't the ones actually doing the abuse, but they were allowing it or negligently failing to stop the abuse from happening. So this can actually absolutely be covered under homeowners insurance policies, which is the same negligence kind of standard. Do you think it should also apply to auto insurance? Now, on the other side, the argument GEICO could make is it's usually while operating the motor vehicle in a negligent manner. And it may depend on the actual language in the policy as to whether or not they can properly deny this claim, which they are always going to try to do. They're always going to try to deny a claim if they have the opportunity to do so. But lastly, an argument GEICO could make is that the car was stationary. They weren't even operating it. It wasn't even moving. That would be another failing argument, and I can give you some experience on that. We have successfully proved claims that stationary vehicles do cause damages negligently. And one of the ways that that happens is somebody parks a U-Haul or a big truck in a place that they shouldn't, and it blocks the view. We've all driven places where you can't see around the side, you can't see, you pull out, boom, another car is coming. Well, we have successfully prosecuted cases against those stationary vehicles against the insured that parked it there, and the insurance policy that says if you negligently handle that vehicle or something negligently happens with that vehicle, which can absolutely be parking it, not just driving it and hitting somebody or turning into somebody's lane or running a red light. No, you can park it in the wrong spot. You negligently operated that vehicle and caused damages. We have had a client where somebody was riding a bike and they couldn't see around the U-Haul, and the car coming from the other side couldn't see around the U-Haul. The client on the bike had to actually go around the parked U-Haul and was crushed by another driver. And the person that rented and insured that U-Haul was held to be at fault at the end of the day. So there are different ways that insurance will come into play than just how it's normally contemplated or how people like you and I may normally think about it on the road. Somebody driving and hits another car, obviously the bodily insurance coverage is going to come into play. But sometimes we don't think about, well, what if they park it in the wrong spot? Or what if it's just in the wrong spot and it's stationary and they're not actually operating it? Can it cover there? The answer is yes. Well, what about if it's stationary and you're using the vehicle for these rendezvous and these romantic links? You're using the vehicle in potentially a negligent manner to negligently pass this injury or cause this injury. Should it attach there? And I'm sure people are going to think that's slimy lawyering, which is fine. If you want to let me know that in the comments, I don't take offense to that. I'm honestly wondering what you all think. I've never had a case like this. I want to know what you all think. Is this a problem, or is this something GEICO should cover? Let me know in the comments and like the video if you like these just one-off random things I see happening in the news when it's right up my alley. These are the kind of cases we have. These are the kind of cases I feel like I know the most about and it can explain the most about. Let me know your questions in the comments. I'm happy to answer them as well. But it was just a wild case when I saw it come through the headline, so I wanted to comment on it. Thank you, everybody, for joining us. Until next time.